pressure off that last year of law school.
Jefferson County Court at Law number 2 is in session. The court is in session on today's date of July 30, 2024. The court is in session with the arraignment docket. Okay, first case that we have is cause number 24 CCCR 1270. Case is style of state of Texas versus, is that Juana Michelle Solomon? And Ms. Solomon, how are you doing?
I'm good.
I'm doing fine, thanks for asking. Ms. Solomon, you're represented in your case by your attorney, Attorney James Paget.
Yes.
Attorney Paget, how are you doing?
Bless, good morning, Your Honor.
That's good. And the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
Great, Judge. How are you?
I'm doing fine, thanks for asking. Now, Ms. Solomon, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down.
Ma'am,
Yes, Ms. Solomon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
You have a check on the line that states that you have hired an attorney whose name is James Paget, and Mr. Paget is currently with you here today. Is that correct?
Yes.
Now, before you signed this document, did you read the document?
Yes, sir.
Or did Mr. Paget go over this document with you?
Yes.
And did you understand everything in this document?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
and Your Honor, I would like to go on the record as stating that Ms. Solomon hired me yesterday. At that time, I filed a letter of representation electronically. And as the court already knows, that paperwork has not been received in the queue for the court. So I would ask that the case be reset for 30 to 45 days to allow me to, number one, be connected to the case, and number two, receive the evidence and evaluate it.
Give us a reset date.
It's gonna be,
And, Wednesday or,
yes, September 18th.
that's perfect. Your Honor.
Okay, this case will be reset to September 18th, 2024. Ms. Solomon, you get your reset from your attorney. Once your attorney give you a reset, you're free to go. And you have a blessed day. And Mr. Paget,
I'll be back to see you.
yes,
Yes, Your Honor.
you'll be free to go as well.
Thank you, Your Honor.
Thank you.
Okay, just, you can kind of see right here.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years and a fine that does not exceed $10,000. Now, on the third-degree felony, you don't go to the state jail, you go to the state penitentiary. Now, the next highest felony is a second-degree felony, and the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the case that you have in this court is not a felony case. Your case is a misdemeanor case. Misdemeanors are divided into 3 categories. We will start at the top and then work our way on down to the bottom. The highest misdemeanor is a Class A misdemeanor. And then you have a Class B misdemeanor and a Class C misdemeanor, which is the lowest misdemeanor. If a person is convicted of a Class C misdemeanor, they can only be given a fine. The fine is normally from $0 to $500. Now, Class C misdemeanors are cases that start or originate in the JP court, which is the justice court, or the city court, which is the municipal court. They only come to this court if a person appealed the case. That is, they get convicted in the JP court or the municipal court, they appeal the case, and then the case comes to this court. Now, when it comes to this court, the punishment range does not change. It's still the same by fine only. Now, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, the court can issue what is called a capias pro fine. That simply means that it's a warrant for the person to be arrested, to pay the fine, or to sit out the time in jail. Now, if a person sits out the time in jail, they receive $100 per day that will go toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, which is 6 months, or a fine that does not exceed $2,000, or a person could be given both such confinement and fine. The next highest misdemeanor, or the highest misdemeanor, is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or a fine that does not exceed $4,000, or the person can receive both such confinement and fine. Now, a person may be eligible for probation. There are two types of probation. One type of probation is called adjudicated probation. That simply means that a person will have a conviction on their record. The other type of probation is called unadjudicated probation. That means that a person does not have a conviction on the record. Now, with the unadjudicated probation, you don't have a conviction on your record, and if you successfully complete the probation, the case will be dismissed. And you may qualify for what is called a non-disclosure. A non-disclosure means that your record is sealed. That is, we cannot disclose the fact to the general public that you are on deferred adjudication. Now, if you qualify to have your record sealed or for the non-disclosure, you notice I said it's sealed or closed from the general public. That simply means that the general public will not have access. However, the government can have access. And in the Texas Code of Criminal Procedure, there are a list of agencies and departments that will have access to your record. But most of the public is the general public. So most of the public cannot have access to your criminal record, or if you receive a non-disclosure on that case. Now, the next misdemeanor, or the next type of probation, rather, is adjudicated probation. I mentioned earlier that you do have a conviction on your record once you get on probation. However, there's something that is called judicial clemency. Judicial clemency means that the court or the judge can set aside the conviction. And if the court sets aside the conviction, you won't have a conviction on your record. And in order to qualify for judicial clemency, a couple of things has to happen. First, you have to successfully complete the probation. Second, there cannot be any more time left on probation. And third, you have to be successfully discharged off of the probation. If those three things happen, the judge or the court has the discretion to set aside your conviction. And if the court sets aside your conviction, you won't have a conviction on your record. Now, however, if you if you get a subsequent or another conviction later on, then this case that you receive judicial clemency on can be resurrected. It can be brought back up, revived, and used against you. And so if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend the license. Now, as a defendant in a criminal case, you have rights. Now, the first right that we will talk about is your right to have an attorney. There's a document on the clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over that document right now. And it states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney to represent you and you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is another document on the clipboard that is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page and half of the second page. And then I'll fill out the remaining half of the second page and the third page. Okay. Once you fill out that document, the proper person will determine whether or not you are eligible for the appointment of a court-appointed attorney. Now, if you want to represent yourself, you'd have to first sign a written waiver of your right to have an attorney to represent you. The written waiver is titled Waiver of Counsel. It's another document on that clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Now, you would have to first read and sign that document. I'm going to go over that document with you in about another minute or two. Now, if you waive your right to an attorney, waive means to give up your right to an attorney, and you desire to represent yourself, you'll have an opportunity to talk to the assistant criminal district attorney who is in court. She was sitting in that chair. She'll be sitting in that chair that's at the table before you. Because you are waiving your right to an attorney, you are representing yourself. You are acting as your own attorney. And so you will be allowed to talk to the prosecutor about your case, but you must first sign the written waiver of right for purposes of entering a guilty plea or proceeding to trial, waiver of counsel. Okay. Now, be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document that's titled Judge's Explanation of Rights to Defendants Without an Attorney, you'll see 5 lines to the left, and it's below a sentence that states, defendant's choice, make mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney, then you will place your initials on the third line to the left. If your choice is, or if you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to an attorney or to give up your right to have an attorney to represent you and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name at the bottom of the document on the line that is titled defendant, and you will date it today's date on the line that is titled date. And the day's date is July 30th of 2024. Now, for those individuals who will be waiving their right to an attorney or giving up their right to an attorney, and they will be representing themselves, you would have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document states that I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is one voluntarily and intelligently made. Now, voluntarily means that no one is forcing you to enter into this waiver. And intelligently meaning that you know what you are doing. And so when it says my waiver is voluntarily and intelligently made, you're saying that one, my waiver is made by me, not by force, it's my own will, and I know what I'm doing. And it says, furthermore, if I have been advised this 30th day of July, 2024, by the county court at law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding that right, I wish to proceed in my case without an attorney or without a counsel being appointed to represent me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that's titled date, and today's date is July 30th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where those young ladies are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence that is presented. They will listen to all of the arguments from the attorneys. They will retire in the jury room to deliberate, and then they will decide whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. And what that means is you have a right not to have a trial by jury, if that's your choice. Now, if you waive or give up your right to have a trial by jury, your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. The trial is known as a bench trial. It's a trial by judge only and no jury. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence that's presented. The judge will listen to the arguments that's made by the attorneys. And then the judge will apply the facts of the case to the law and decide whether to find you not guilty or guilty. Another way that your case can come before the judge is by way of a plea bargain. Now, a plea bargain means that you and the state of Texas or the district attorney's office have come to an agreement to settle your case. We call that a plea bargain agreement. If you have an attorney, your attorney can work out a plea bargain agreement with them, or if you represent yourself, you can work out a plea bargain with them. We call that a plea bargain. Now, you could enter one of 3 types of pleas. You could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Now, if you enter a plea of guilty and no contest, and you enter into a plea bargain with the state, we call that an agreed plea bargain agreement. In essence, we have an agreement. Now, your case will come before the judge. the judge can do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge accepts the plea bargain agreement and within 30 days you decide that you would like to appeal because you think that, well, you were wrongfully convicted, or you think that the court committed an error by convicting you, then you have to get permission from the judge to appeal your case. If the judge follows the plea bargain agreement, you have to get permission from the judge. If the judge gives you permission, then your case is going to leave this court and go to another court. It's going to go upstairs to the Ninth Court of Appeals. They will review your case to see whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. They can do one of two things. They could either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeal. You can appeal your case to the highest criminal court in the state of Texas. And that court is the Texas Court of Criminal Appeals. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means that you'll be representing yourself. You won't have a lawyer representing, and you'll be petitioning the Texas Court of Criminal Appeals to review your case. Why? To see whether or not your appeal should have been granted, or whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. Now, the Texas Court of Criminal Appeals could do one of two things. They could either grant your pro se petition, or they can deny your pro se petition. If they grant your pro se petition, then they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals with orders, or they could send the court case back down to this court, or to this court to give you a whole new trial, or the order this court to give you a whole new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. Now, the other way that your case can come before the court, not only by way of a bench trial or an agreed plea bargain, it can come by way of an unagreed plea bargain. An unagreed plea bargain means that you and the state have talked, or you and your attorney and the state have talked, and you couldn't work out an agreement. However, you still want to enter a plea of guilty of no contest, and you want the judge or the court to decide what your punishment will be within the punishment range. Now, the judge can assess your punishment anywhere within that punishment range. Now, you also have a right to have witnesses to come to court. Witnesses, and we talking about if you're having a trial, you have a right to have witnesses to come to court. Witnesses, they sit in that chair where the microphone is. We call that the witness stand. And what witnesses do, they can testify. They can testify for you or against you. If you're representing yourself, you can ask them questions, or if you have an attorney representing you, your attorney can ask them questions. And we call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That means that you will not be calling witnesses to testify. However, it does not mean that the state will not be calling witnesses to testify, because they will be calling witnesses to testify in your case. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. The state of Texas, the government, the DA's office cannot force you to take the witness stand if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. That is, if you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be taking a witness stand. Now, the other right that you have is a right to have what we call discovery. Discovery means you have a right to see the evidence that the state, or have access to the evidence that the state will be using against you. If you have a lawyer, your lawyer will have access to it. If you represent yourself, you will be having access to it. We call it discovery. In essence, you have a right to discover or see or have access to the evidence that the state will be using against you. Now, you also have a right to waive or give up your right to have discovery. By waiving or giving up the right to have discovery, that simply means that you will not be having access to the discovery in the case. Now, everyone that's here today for arraignment, you have been arrested, you were placed in jail, and you were released. That's why you're here today. And you're out of jail on either a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you are out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court today. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and your attorney have negotiated with the prosecutor, and the prosecutor is offering for you to serve 5 days in jail. That simply means that you will not have to serve any more times in jail. You can't come in here with that drink. Okay, that means you can't serve any more time in jail. That because you've already served 5 days in jail, therefore you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you would only have to serve 2 days in jail. Why? Because you already have 5 days in jail, and we'll take 5 from the 7, and that leaves 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. Every day that you spent in jail, you will credit it at $100 per day. That will go toward your fine and court costs. So, for example, you and the state have talked, or you and your attorney have talked to the state, and the state is offering you a fine and court costs of $500. You spent 5 days in jail. That means you won't have to pay anything. Why? Because 5 days in jail is $500. And so the fine and court costs will be taxed and retired. You've already paid it. Now, if they're offering $700 fine and court costs, and you spent 5 days in jail, which means you have $500 credit, then you will only have to pay $200, because we will take the 500 from the 200, from the 700, 5 from the 700, and that will leave $200 to be paid. And the $200 is to be paid on the day of the plea. Now, if you cannot pay the $200 on the day of the plea, then we can do first of all, we can put you on what is called a payment plan and allow you to pay it off in monthly installments. Now, if you can't pay it off in monthly installments because you do not have the income, no problem, because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform, you will receive $12.50 that will go toward the payment of your fine and court costs. So if you work 8 hours one day, community service, that's $100. So if you work 2 8-hour days, that's $200, and it will pay off the $200 that you owe. Now, Jefferson County has a program for first-time offenders. Now, if you haven't been in trouble before, Jefferson County has a program, and when I say Jefferson County, I'm talking about the district attorney's office, they have a program that is called pretrial diversion. Pretrial diversion is a program where they will dismiss your case and you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your record. Now, in order to qualify for the program, it cannot be an offense involving unless you're carrying a weapon or resisting arrest. It has to be your first time getting in trouble. And you have to have an attorney to help you with filing the application to the district attorney's office. Now, if you get into the pretrial diversion program, again, case will be dismissed. You complete the program, you can get it expunged from your record, which is erased, deleted, or wiped off, like it never happened. Now, if you're interested in that program, just let us know when we ask you to come up, and we can direct you to the person that you need to talk to about the program. Now, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's for veterans only. And with the Veterans Court program, only thing you have to do to qualify is be a veteran of any one of the branches of the United States military. And if you get in the Veterans Court and you complete the Veterans Court program, the case will be dismissed and you can get what is called a non-disclosure. A non-disclosure means that we cannot disclose the fact to the general public that you were on defer, that you were in the Veterans Court program or that you had this case. Okay? And notice that saying when I say non-disclosure, that is it's sealed to the general public. Now, certain governmental entities can have access, but most the general public cannot have access to it. All right. Now, this court has a program that is called the CSI program. That is a program that I started within the first 100 days of taking office. That program was started in March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism where people commit crimes over and over. And so the way we address recidivism is through our CSI program, which means Community Safety Initiative. It's an acronym for Community Safety Initiative. And with that program, we have partnerships in the community. One of the partnerships that we have is this partnership with Spindletop. Spindletop is our local mental health agency in Southeast Texas. And they will come before you in a little bit and tell you more about the program that Spindletop has to offer. But basically, Spindletop, they have the ability to do a private interview either here in the jury room or at their facilities or over the phone, depending on what is convenient for you. They also have the ability to do an assessment, develop a treatment plan, either outpatient, inpatient, depending on your mental health needs. Now, when I say mental health needs, you don't have to be incompetent or insane. You could just simply suffer from anxiety or depression or any other host of mental illnesses. They have the expertise and the ability to address your mental health needs. Now, Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council, and they have a program that is called OSAR. OSAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. So if you have issues with drugs or alcohol, they have the ability to do an assessment, to do a screening, an assessment, and they can refer you for either outpatient or inpatient treatment, depending on what your drug and alcohol addiction needs are. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center who has a partnership with Lamar University. Lamar University has a program that is called CICE, and it is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will also assist you at getting a job in the area that you train in. So they have job placement. Now, if you haven't graduated from high school or if you do not have your GED, well, CICE also they also have a GED program. And with that program, you can get your graduate equivalency diploma, your GED. Now, all of these programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. And it's not, and what I mean by that is we don't just arrest the problem. We address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we are trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Why? Because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to assist you at getting in any one of the programs that you're interested in. The other thing about these programs is they all can be used as community service. So for example, let's say you are ordered to pay a fine and court costs, but you do not have the funds to pay the fine and court costs because the court has found that you're indigent. Then if you participate in any one of these programs, let's say you're in the job training program. For every 1 hour you're in that job training program, $12.50 will be going toward payment of your fine. Or if you are in a drug treatment program, $12.50 will go toward payment of your fine. Or if you're getting mental health treatment, and you're in that 1 hour, $12.50 will go toward payment of your fine and court costs. So all of these programs can be used as community service. That is the mental health program, drug and alcohol recovery program, the job training program, the job placement program, and GED program. So for every 1 hour that you spend in any one of them, it can be used as community service to pay your fine and court costs. Now, as I mentioned earlier, we have some folks from Spindletop that's going to come before you and tell you more about the program that Spindletop has to offer. And we have Deputy Hinton and Chris. They're going to come forward and tell you more about the program that Spindletop has to offer.
Thank you, Your Honor.
You're welcome.
Good morning.
I have seen from your health deputy officer, say, this is qualified mental health professional. Reason we were both here this morning. The judge hears by every single person.
Judge has found this is free. Both of needs, substance use disorders, or sometimes just lack of community resources.
Now, But the way you just, but, you know, I really break you, they're both pondering. And that's it. Statewide, there's a fascination, that's actually. They're great, but even finding the name for one of them can be a bit like jumping through hoops, and if you're already juggling all the other stuff outside of that, it's just, even something can help, you know, thing up. That's kind of where we come in. But I know the judge mentioned, inpatient, outpatient stuff, that's again just resources we can connect you to, we don't send people, please don't worry about that. And the first treatment plan is just looking at what you might need as far as resources, and giving you the opportunity to talk if you want to. A lot of times the resource that we find most people are lacking is just sometimes support. And that's one of the main reasons we're here for, is really just to help. If there's anything you need or anything you want, have it, we're here for, just help.
So maybe this is your first time to be in court, could be your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life. But we're gonna need something from you, we're gonna need you to share that need with us, so we can best determine how to advocate for you, get you pointed in the right direction. And Chris will show you exactly how you can do that very privately.
So I handed this out to everybody that came in, right? Every single person got one of these, and the reason that is because this is a giant pencil. We function in a way where it doesn't matter if you're here as a defendant or if you're here to support, if you need information for you or somebody you care about. We're just here, right? This is built like a baseline to put things in. The reason it is built this way, is, you know, so that you know that any information you put on the sheet is protected under state law, the same as your medical information. That's why we made it this way. The only thing you're consenting to is me reaching out to you once and then you choosing or speaking to you privately if you want to. No one else is gonna do this with me. No one else will call you but me. If there's something you need, please give us a chance to have it. Or if there's something that you just want to talk about again, we're here, right? Usually a lot more eloquent than this, so I apologize. But that's really what I want to get across to you guys is that we're here because this is not, again, a moment where you knows what to expect from. And you all showed up today. I'm sure there was names that were called outside that aren't in this room. And that's not going against them. Sometimes life happens and you can't make it for it, but you all showed up. We know you work hard for yourself. We know that you want to help. You want to work hard for you, do good for yourself. It's never going to be a low situation or something where everyone is going to do anything like that. If you have a time of the day that works best for you, let us know. If you have a way that works best for you, reach out, tell me. We want to meet you where you are and meet you. I know there's already a lot of things that people are doing. We don't want to add to that. Anything we set up with, first I check with as well. So we're thinking about the resources. And if anything that we set you up with is not going to be, it's not going to be a financial stress. We're not trying to add anything. It's going to be either slowly funded or sliding fee scale, and we are already funded by the state. We don't have to worry about anything with us. So if there's something you need, we want to help you fund it.
Also have this business card here that I want to get in everyone's hands before you leave here today. On the back, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately.
So what's important about that is it actually is the first resource we can give you. And this is why I said resources approximation, right? That number is active almost statewide. I say almost because we all know there's plenty of places that there's been no phone work, no matter what you do. But that is 24/7. You call them at 6 a.m. on Christmas Day. If you're in the middle of crisis or somebody you care about is experiencing a lot of emotions, they need help immediately. That is the number for that. You'll get the number that will contact you from the sheet or the email or however you want. It's going to be my contact. It goes straight to me. That's going to be the other resource you get. But again, we understand a lot of times people end up in court in Jefferson County. They're from the run close to here. It doesn't matter. If there's a works of people at home, because they're you want to put up, you want to. And I know this is now when people want to be in, or you want to do it. There are other things that we can do to help us out here. We can make it a little bit.
Shortly, before everyone will reset, the best will be able to come out there, we'll visit with you, we'll talk to you, understanding this out there. We'll be able to answer any questions. Thank you, Ron.
Okay, thank you, Chris and Deputy Hinton. Now, ladies and gentlemen, we're going to go into recess in a few minutes. But before we go into recess, I need to give you some additional instructions. And that is the paperwork that you have on your clipboards. If you need any help, we have our core personnel who's here to assist you at filling out the paperwork. Now, we're gonna take up the paperwork from you and then we'll have to go through it. And then after we go through the paperwork, we're gonna call you up before the bench, one at a time. Now, as I mentioned earlier, this is gonna take us a little time. Now, if you need to use the restroom, there are two restrooms in the hallway. One restroom, the men's restroom, is right in front of County Court at Law number 3, which is next door to us. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, please do not leave the courthouse. If you leave the courthouse and if your name is called, you're not here, then a warrant, your bond can be forfeited. A warrant could be issued for your arrest and you'll be arrested and placed in Jefferson County Jail. Now, as I mentioned earlier, if you need any help, just please raise your hand. We have our core personnel who will be happy to help you with filling out that paperwork. So at this time, the court is going to go into recess. Jefferson County Court at Law number 2 is back in session. Court is in session with its arraignment docket on today's date of July 30th, 2024. You have Mr. Booker. Your query is Booker. Is that the
Yes.
gentleman?
He was still talking and still.
Okay, okay.
I mean, it's no.
Next case is cause number 24 CCCR 1256, case of style state of Texas versus Cedric Marsh. Marsh, would you please come forward? Mr. Marsh, your full name is Cedric Marsh?
Yes, sir.
Mr. Marsh, would you please raise your right hand? Mr. Marsh, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Marsh, you may put your hand down. How are you doing, Mr. Marsh?
I'm good.
That's good, Mr. Marsh. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you want to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes,
Mr. Marsh, before you signed and initialed these documents that I just showed you, did you read the documents?
yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Marsh, I read your answers. Based on your answers, you'll have an opportunity to talk to the prosecutor who is here in court. Just go have a seat back where you were sitting, and the prosecutor is going to come out and talk to you.
Yes, sir.
Next case is call number 23 CCCR 1202, case of style of the state of Texas versus Earl Keeling. Mr. Keeling, your full name is Earl Keeling?
Yes, sir.
Mr. Keeling, would you please raise your right hand? Mr. Keeling, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Keeling, you may put your hand down. How are you doing, Mr. Keeling?
All right.
That's good, Mr. Keeling. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Keeling, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Keeling, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir.
Amadre Lawrence Woodridge. Mr. Woodridge, your full name is Ahmad Trelawrence Woodridge.
Yes, sir.
Mr. Woodridge, would you please raise your right hand? Mr. Woodridge, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Woodridge, you may put your hand down. How are you doing, Mr. Woodridge?
How you doing?
I'm doing fine, thanks for asking, Mr. Woodridge. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's the signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Woodruff, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Woodrich, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that third chair on the wall. Benaiah Johnson. Ms. Johnson, your full name is Kenaya Johnson. Ms. Johnson, would you please raise your right hand? Ms. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Johnson, you may put your hand down. How are you doing, Ms. Johnson? I'm doing fine, thanks for asking. Ms. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. Johnson, before you sign and initial these documents, did you read the document? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Excuse me. I read your answers. One of the prosecutor is going to come out and talk to you. Okay, just go have a seat where you're sitting, and she'll call your name. Tisha Juan Mack. Mr. Mack, your full name is Tijuan Mack. Mr. Mack, would you please raise your right hand? Mr. Mack, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Mack, you may put your hand down. How are you doing, Mr. Mack? I'm doing fine, thanks for asking. Mr. Mack, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendants? Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Mack, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Mack, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney John Mason. Attorney John Mason will be given information to contact you. You will also be given information to contact him. But before I give you that information, we need to give you some bond conditions. Mr. Mack, the bailiff is handing you a document that is titled Standard Bond Conditions in County Code Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over these bond conditions with you, and it reads as follows. I want to return for criminal information in County Code Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Mack, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, now, Mr. Mack, you're gonna sit in that first chair on the wall and wait for your name to be called. Once your name is called, you'll go to the window, and once you finish at the, that door is locked, sir. You'll go to the window, and once you finish at that window, you're free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Sheldon Alexander. Mr. Alexander, this is cause number 24CCCR 0676. Your full name is Sheldon A. Alexander. Mr. Alexander, would you please raise your right hand? Mr. Alexander, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Alexander, how are you doing? You may put your hand down. I'm doing fine, Mr. Alexander. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
And Mr. Alexander, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Alexander, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Reagan Minaldi. Attorney Minaldi will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that third chair on the wall. Alexis Blue. Your full name is Alexis L. Blue?
Yes.
Blue, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Blue, you may put your hand down. How are you doing, Ms. Blue? I'm doing fine, thanks for asking, Ms. Blue. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On the next page of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Blue, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Blue, I read your answers. Based on your answers, you meet the eligibility requirements of the court-appointed attorney. Attorney that will be appointed to represent you is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. You're welcome. Henry Thomas. Mr. Thomas, your full name is Henry Thomas? Thomas, would you please raise your right hand? Mr. Thomas, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thomas, you may put your hand down. How are you doing, Mr. Thomas? That's good, Mr. Thomas. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled Defendant? Or these your initials on the line that state you like to apply for court appointed attorneys? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Thomas, before you signed and initial these documents that I just showed you, did you read the documents?
Sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Mr. Thomas, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you. You will also be given information to contact him. Once our court coordinator gives you that information, you'll be free to go. You have a blessed day. Now, Mr. Thomas, please have a seat in that 5th chair on the left.
This was Mr. Thomas, Judge.
Yeah, he's the last one, Mr. Yeah, Mr. Thomas is the last one. Okay. Jaquarius Booker. Where is,
I'm right here, Your Honor.
oh, Booker, all right. Mr. Booker, your full name is Jaquarius Booker?
Yes, sir.
Mr. Booker, would you please raise your right hand? Mr. Booker, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Booker, you may put your hand down. How are you doing, Mr. Booker?
I'm doing all right.
That's good, Mr. Booker. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, it is, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Booker, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct
Yes, sir.
to the best of your knowledge?
Yes, it is.
Okay. Now, Mr. Booker, I read your answers. Your case is going to be reset to give you the opportunity to hire your own attorney. Please have a seat in the jury box.
Yes, sir.
Will be in recess. Next, 3 cases. Kevin Dwayne Pugh. Pugh, would you please come forward with your attorney?
Good morning.
Good morning. Now, Mr. Pugh, your full name is Kevin Dwayne Pugh.
Yes, sir.
Mr. Pugh, would you please raise your right hand? Mr. Pugh, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Pugh, you may put your hand down. How are you doing, Mr. Pugh?
Right.
You're doing great. That's good. Now, Mr. Pugh, you represented in your cases by your attorney, Attorney Joel Vasquez. Attorney Vasquez, how are you doing?
Good, Your Honor. How about you?
I'm doing fine. Thanks for asking. Vasquez. Do you waive a record in Mr. Pugh's cases?
Yes, Your Honor.
Wait for this here thing. Come on.
Judge, we're the only ones who will remember Jethro Hill.
Mhm. Dallas Cowboys.
Right, you gotta call me out like that.
I can always go to Judge Holmes on the spot there.
Yeah, here's tell me about it. I've never seen it.
You have,
And
You do
this
the other
is,
one,
oh,
Judge?
just
we
one case.
segue into the Beverly Hills.
It's 2 cases and 1 dismissal. This is the other discovery.
Oh, okay.
What'd you say?
Okay, this is. Court is in session in 3 cases, cause numbers 24 CCCR 0456, cause number 24 CCCR 0498, and cause number 24 CCCR 0732. In all 3 cases, Style, State of Texas versus Kevin, is that Kevin Dwayne Pugh?
Yes, sir.
Okay, Mr. Pugh, I have before me in cause number 24 CCCR 0456, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Pugh, it alleges that you, Kevin Dwayne Pugh, on or about January 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of burglary of a vehicle. Now, Mr. Pugh, do you understand what you have been charged with?
Yes, sir.
And to discharge Mr. Pugh, how do you plead? Guilty, not guilty, or no contest? No contest? Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Pugh, I also have before me a document that is titled misdemeanor plea admonishments. This document is also labeled as State's Exhibit number 1. In this document, now, Mr. Pugh, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Pugh, there are a set of initials, KP, that are on a line next to a box, just check number contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Sir, yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement?
sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I have another document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant?
Sir, yes, sir.
Mr. Pugh, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over.
Sir, yes, sir.
Mr. Pugh, are you a citizen of the United States?
Yes, I am, sir.
State upper states one.
Any
No.
objections?
No objection.
No objection. States Exhibit number 1 will be admitted. Mr. Vasquez, you've advised and counseled Mr. Pugh. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Pugh, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, I am, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Pugh, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 169 days in the Jefferson County Jail, credit for 169 days, and 2 tax and retirement court costs.
Mr. Pugh, the state is offering that you serve 169 days in the Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 169 days in the Jefferson County Jail. And the court costs, in this case, Mr. Pugh, will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Pugh, do you understand the state's offer?
Sir, yes, sir. I understand the state law.
Do you think that the state's offer in your case is fair and just?
Sir, yes, sir. I think it is.
And do you accept the state's offer?
Yes, sir.
Mr. Pugh, I'll follow the plea bargain agreement that you have entered into with the state. And Mr. Pugh, we'll move to your next case. And your next case is the next case is cause number 24CCCR 0498. And I have before me a document that is titled misdemeanor plea that's titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Kevin D. Pugh, on or about January 3rd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of controlled substance, penalty group 2A. Mr. Pugh, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Pugh, how do you plead? Guilty, not guilty, or no contest? You pleading no contest?
Yes, sir.
Now, are you pleading no contest freely and voluntarily?
Yes.
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Mr. Pugh, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a set of initials, KP, that are on the line next to boxes checked, no contest,
Yes, sir.
no contender. Do you recognize this? What are these your initials that you placed on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
I understand, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that that is titled Discovery Certification. You recognize this document?
Understood.
And is this your signature on the line that's titled Defendant?
Yes,
Mr. Pugh, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
yes, sir, I did.
And did you read and understand everything in these documents?
Yes, sir, I did.
And is everything in these documents true and correct
Yes, sir, I did.
to the best of your knowledge?
Yes, sir, I did.
State,
State officer states one.
any
Okay.
objections?
No
No objections. States exhibit number 1 will be admitted. And Mr. Vasquez, you've advised and counseled Mr. Pugh. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Pugh, your attorney, Mr. Vasquez, has advised and counseled you in this case. Are you satisfied with the services in this case?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Pugh? Do you accept this? Mr. Pugh, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 169 days in the Jefferson County Jail, credit for 169 and 2 tax and retired court costs.
Mr. Pugh, the state is offering that you serve 169 days in Jefferson County Jail. However, you not have to serve any more time in the Jefferson County Jail because you've already served 169 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Pugh, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir, I do.
And do you accept the state's offer?
Yes, sir, I do.
Mr. Pugh, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Pugh, we'll move to your last case. And I have before me cause number 24CCCR 0732. State, I have before me a motion to dismiss. Is that correct?
Yes, Your Honor.
Mr. Pugh, and the state want me to grant this motion to dismiss.
Yes, Your Honor.
Mr. Pugh, I'm signing the dismissal in cause number 24CCCR 0732. Mr. Pugh, your attorney, you're gonna stand in front of the court coordinator. You're gonna follow the directions of the bailiff. Once you finish following her directions, you can follow the bailiff and you have a blessed day. Please stand in front of the, we need to hold on a minute. Hold on a minute. like 1,000, whatever. Okay, so this is, okay. This is cause number 23 CCCR 1259. And cause number 23 CCCR 1260. He's on here twice.
I believe he has three cases,
Three.
Judge.
3 cases.
Looking for the fourth.
James not.
See? 2 out of 3.
Oh, and the third case is cause number M 324960, and I would imagine that's the NTRP.
I'm not working.
All-
Shake him to look at it.
Yeah, that's the oldest
That's
one.
it. That's the oldest one.
All three cases are styled the state of Texas versus Joseph Janiel Benitez Gomez. Mr. Gomez, is that your full name? All right. Now, Mr. Gomez, you are represented by your attorney, Attorney Paget, and cause numbers 23 CCCR 1259 and cause number M 324960. Is that correct, Mr. Paget?
And I will be on the other one, as well. Just currently not in this
Okay.
particular second, but
Okay.
I can announce on my
Okay.
2 and the other. If you'll put the other one along with it, we'll take care of that.
Okay, so what's your announcement?
I need 30 days on a plea, Your Honor. So this is Mr. Hubel's case. And Mr. Hubel is recommended 45 days county jail in exchange for dismissal on the other 2 cases. So he has a felony down the hall as well. So I've set that. That case is being set on September the 10th. And if we could put this
On
one
the
on
same day?
September 10th, we will be
Okay.
pleading down the hall and we will be pleading on the misdemeanor case.
Okay, September 10th. Okay, all three of these cases will be reset to September 10th, 2024. Mr. Gomez, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Thank
And
you, Your
you'll be
Honor.
free to go as well.
May I
Mr.
be
Paget.
excused?
Yes,
Thank you.
you have a blessed day.
And I'll be in touch.
Okay.
Okay, so, that's. And so it's 45 days, minus your jail credit. You pay on that, so make preparations for that day.
I got a debit card, I don't know.
And if you need something that, you know, have that following.
Mr. Paget, Gomez,
Yes, sure, Mr.
the court coordinator needs her,
Oh, wow.
needs him.
You know, Frank. What's the word for you? You're free to go. After she gives you that.
There's a separate case for that.
Okay, okay.
Hmm. I mean, I guess if they're around, look at the other case that was on the docket.
She need to put the numbers on both of them. And she has 2 pages.
Use probation. By the name. Probation. You see, 3 to 6 weeks, it's like, really. From 6 weeks to 2. There's this. The whole year.
Did we already add? Okay, they still working on that? Mr. Vasquez,
Yeah, sure.
did you Court is back in session in cause number 2366CR 1610. Case is styled the state of Texas versus Guerrero Marcus Delatorre.
Yes, sir.
Mr. Delatorre, would you please raise your right hand? Mr. Delatorre, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Delatorre, how are you doing?
Okay.
You okay? That's good. Now, Mr. Delatorre, I have before me a document that is the other county affidavit of indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document. Oh, we've got to give him the judge's explanation too. On page 2 of this document, there's a signature above the line. Oh, he didn't sign it. Miss Mosby. He has to sign here and here. Give him, and he has to sign and date it. That's your signature and the day's date. Is she getting him a judge's explanation? Okay. Mr. Delatorre, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Now, Mr. Delatorre, this document states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
Yes, sir.
Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number 3, you may represent yourself. Do you understand that option?
Yes, sir.
Now, this document further states that if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Do you understand that?
Yes, sir.
And if you want an attorney and you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Do you understand that?
Yeah.
You may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Do you understand that?
Yes, sir.
Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possessing a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that?
Yes, sir.
Now, if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that?
Yes, sir.
Now, at the bottom of this document, in bold points, it says defendant choice, mark your initials next to only one choice. Now, you have placed your initials on the line that state you would like to apply for a court-appointed attorney. Is that correct?
Yes, sir.
And this is your signature on the line that's titled defendant, and the day's date is dated July 30 to 2024.
Yes, sir.
All right, now, do you understand everything in this document?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, you have another document before you. That document is titled Jefferson County Affidavit of Indigence. And on page 2 of that document, there's a signature above on the left, at the top left-hand corner, where it says defendant's signature. Is that your signature? Look at on the second page, to the left, at the top.
This one here?
Yes, that's your signature at the top?
Yes, sir.
Okay, now, before you sign all of these documents, did you understand everything in the documents?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Delatorre, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. All right, Mr. Vasquez is here. You can have a seat and you can talk to Mr. Vasquez.
Thank you, Judge.
Okay, Ms. Johnson, I have before me two cases, cause numbers 23 CCCR 1844 and cause number 24 CCCR 1092. Both cases are styled the state of Texas versus Kenesha, what's that, Kanaya Johnson. And Ms. Johnson, is that your full name? Okay, Ms. Johnson, would you please raise your right hand? Ms. Johnson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Okay, now, Ms. Johnson, previously you came up before us, or before me, and you stated that you wanted to waive your right to attorney and represent yourself. Is that correct?
Sir.
Now, do you still want to do that, or do you want to?
No.
Okay, now what do you want to do? You have the option to either hire an attorney. If you cannot afford to hire an attorney, you have the option to apply for a court-appointed attorney. Okay, she's gonna give her a clipboard with the Jefferson County Affidavit of Indigence on. She's gonna give you a clipboard to fill out. She can go back and have a seat. Okay, I think we have his paperwork ready. No, we don't.
I had Mr. Marsh earlier.
Oh, we have Marsh. Okay, Mr. Marsh, you please come forward. Jefferson County Court Law number 2 is back in session. The court is in session and calls number 24 CCCR 1256. Case is styled the state of Texas versus Cedric Marsh. Mr. Marsh, is that your full name?
Yes, sir.
Mr. Marsh, would you please raise your right hand? Mr. Marsh, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Marsh, you may put your hand down. Mr. Marsh, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you want to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line as title defendant?
Yes, sir.
Mr. Morris? Before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Morris, I also have another document before me on my computer. This document is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Morris, it alleged, well, it states, Mr. Morris, that this is a Class B misdemeanor, the range of punishment confinement in the county jail that does not exceed 180 days, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand that
Yes, sir.
range of punishment? Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials below a paragraph that's titled waiver, and it's next to a box that's titled nolo contendere, which means no contest.
Sorry.
Now, Mr. Morris, you pleading no contest in this case?
Yes, sir.
Okay. Now, Mr. Morris, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay. Now, Mr. Morris, on State's Exhibit number 1, the misdemeanor plea admonishments, did you place your initials on this line next to a box that's checked nolo contendere,
Yes, sir.
which means no contest? There's a second set of initials below a paragraph that is titled discovery admonishment. And are these your initials?
Yes, sir.
And these initials are on the line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest.
Yes, sir.
And these are your initials on this line, is that correct?
Yes.
That you placed on it. On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Now, Mr. March. I also have a document that is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have, now, Mr. Morse, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Morse, are you a citizen of the United States?
Yes, sir.
State up for states 1.
Now, Mr. Morse, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the document, the first document on the tablet that you acknowledge. This is the same document that have your initials on the 2 locations on page 2 and your signature above the line is titled defendant on page 3. The state would like to use these documents as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, now, Mr. Morris, prior to us entering into or starting this plea, you stated that you were waiving your right to a record, a court report. Is that correct? Is that correct?
Yes, sir.
All right. Now, Mr. Morris, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay. Mr. Morris, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 6 months deferred, $250 fine, 40 hours community service plus court costs.
200. What is this court cost?
Oh.
277?
Yes.
Let's see. Okay. Mr. Marsh, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll be required to pay a fine of $250 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, and a reimbursement fee of $15. You will be required to pay this amount in monthly installments. And you'll be required to pay $198 a month. Are you able to pay the $198 each month? Okay, now, let's do this here. Did he have an affidavit of indigence? Hold on a minute. Mr. Marsh. Okay. I have before me a document that is titled Affidavit of Indigence, Miss Mosley, could you hand this document to Mr. Marsh? Ms. Marsh, do you recognize that document? You go to, on the back page, on page 1, I think there's a signature above the line that is titled Defend the Signature, top left-hand corner. Is that your signature? Is that your signature?
No, sir.
Your middle name is Levon?
Oh, yes, sir.
This not your signature? You just did it since that.
Where, is that the
Oh,
top
okay.
left-hand corner?
Oh, wait a minute.
No.
On the back page.
It's not signed.
Let me see, I thought I saw it.
The magistrate.
Not that, the back page of page 1
Oh,
is right here.
okay. Right here.
Yes, sir.
Okay, now, is everything in that document still true and correct today? Go back to the first page talking about your financial situation, or has it changed? But is it still true and correct?
It's the same.
Okay. Now, Mr. Marsh, the court is going to find that you are indigent. Okay, now the court is gonna find that you're indigent. Based on that finding of indigency. Pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The fine and court costs, which comes to a total of $527, will be converted to 42 hours of community service. The probation fee will be reduced to the statutory minimum of $25 a month. You will be required to pay a urinalysis fee of $15 a month. And the reimbursement fee in this case, because you are indigent, will be waived pursuant to Article 102.018 subsection B of the Texas Code of Criminal Procedure. So you won't have to pay that. So that means that you'll be paying a total each month of $45 a month. Would you be able to pay that?
Yes, sir.
Okay. Actually, it'd be $40 a month. Yeah. Now, Mr. Marsh, you will also be required to perform 40 hours of community service in addition to the 42 hours that was converted from the fine and court cost. So it comes to a total of 82 hours of community service. Do you understand that?
Yes, sir.
Now, Mr. Marsh, you will also be required to adhere to the other standard terms and condition of probation. And do you understand that?
Yes, sir.
Okay. Now, Mr. Marsh, do you understand the state's offer
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Morse, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Morse, just have a seat in that chair. She's working on your paperwork. Once she finishes with your paperwork, she's gonna call you up to the one, then you can follow the directions of the bailiffs. We're gonna have. Reduce the fee to $25, and I waived the $15 reimbursement fee. And this is this is the article. 102.018 of the Texas Code of Criminal Procedures. Yeah, that's why pursuant to that, you're gonna put that article in there. Do we have Mr. Delatorre?
Oh, I think.
Yeah, I got it. Guerrero Marcus Delatorre. Would you come forward? Mr. Delatorre. Your full name is Guerrero Marcus Delatorre. Mr. Delatorre, would you please raise your right hand? Mr. Delatorre, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Delatorre, you may put your hand down. Mr. Delatorre, you're represented in your case by your attorney, Attorney Joel Vasquez. Attorney Vasquez, do you waive a record in Mr. Delatorre's case?
Yeah, sure.
Mr. Delatorre, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Delatorre, it alleges that you, Guerrero Marcus Delatorre, on or about June 24th of 2023, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of criminal trespass. Mr. Delatorre, do you understand what you've been charged with?
Yes,
And to this charge, Mr. Delatorre, how do you plead guilty, not guilty, no contest?
guilty.
Are you pleading
No, no,
guilty,
no con- no.
no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Delatorre, I also have before me on this tablet, a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, MAD, on a line next to a box that's checked NOLA contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
And on the next, how you get MAD out of DMD?
My first name is Marcus. My second, my middle name is Anthony. and my
Oh,
last
they
name-
got you on here as Guerrero Marcus Delatorre on the, okay. So let me back up. I'm looking at the information sheet that's been filed by the Jefferson County District Attorney's Office. And it states that you, Guerrero Marcus Delatorre, on or about June 24th of 2023, committed the Class B misdemeanor offense of criminal trespass. You understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead?
No contact.
And are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, also, I have before me states exhibit number 1, the misdemeanor plea admonishment, and you recognize this document?
Yes, sir.
On page 2, of this document, it has initials MAD on a line that's next to a box that's checking the contender. And did you place your initials on this document?
Yes, sir.
And the MAD stands for what?
Marcus Anthony De La Torre.
Marcus Anthony De La Torre. So that's your name, and so I guess this other name is an AKA, also known as.
Well, I'm actually, De La Torre Guerrero comes from, my grandma and my mom's last name. So Guerrero De La Torre is my last name. My first name is Marcus.
Guerrero del Toro is one name?
No, that's my both last names.
Okay, so it should be Marcus. Well, it's Marcus Guerrero De La Torre. I mean, right now, he's just, that's his AKA.
It is.
Yeah.
Okay.
Now, on page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
And also, I have a document that's titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. De La Torre, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. De La Torre, are you a citizen of the United States?
Yes, sir.
State up for state one.
No objection.
No objection, states exhibit number 1 will be admitted. And Mr. Vasquez, you've advised and counseled Mr. De La Torre. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. De La Torre, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. De La Torre, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
In exchange for defendant's plea, the state's offering 60 days in the Jefferson County Jail, credit for 60, and 2 tax and retirement court costs.
Okay, now, Mr. De La Torre, the state is offering that you serve 60 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you've already served 60 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. De La Torre, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. De La Torre, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. De La Torre, this will conclude your case. You're going, in a few minutes, you're gonna stand over there by the bailiff and follow her directions. And once you finish following her directions, you'll be free to go. And you have a blessed day.
Likewise.
All right, thank you.
Thank you, Judge.
Okay, thank you, and you have a blessed day as well, Mr. Vasquez.
You too, Your Honor.
Okay.
I'm not announcing about it.
I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And the waiver of counsel for purposes of entering a guilty plea or proceeding trial. You previously were sworn in, is that correct? And you acknowledge that you recognize these documents and that you read these documents and everything in these documents are true and correct to the best of your knowledge. Now I think, since you changed your mind from wanting to represent yourself to wanting to get a court-appointed attorney,
It's gonna do that. She was trying to get in the pretrial diversion program, Judge.
oh, okay. She needs us, put a line through there and put her initials on the, third line that says she wants to apply for court-appointed attorney.
No, she did waive her right to, she ended up changing her mind. She's waived her right to both and she's going through a plea on both charges.
Oh, I didn't know that.
Wait, something changed?
Oh,
I've sent the plea paperwork.
oh, I didn't
That's
know.
what I've been waiting
Oh, just have a seat. Oh, Okay. Ms. Johnson, would you please raise your right hand? Ms. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Johnson, I have before me, there's an explanation of rights to defendants without attorney and the waiver of counsel for purposes of entering a guilty plea. And Ms. Johnson, you previously acknowledged these two documents, is that correct?
Yes, sir.
And you also stated that before you signed and initialed these documents, you read the documents, is that
Yes,
correct?
sir.
And that everything in these documents are true and correct to the best of your knowledge.
Yes, sir.
And you also stated that you understood everything that's in these documents. Okay. I also have before me a document on my computer that is titled Information Sheet N cause number 23CCCR 1844. This document states that you, Kanaya Johnson, on or about June 26th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Johnson, do you understand what you have been charged with? And to this charge, Ms. Johnson, how do you plead? Guilty, not guilty, or no contest? No contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Yeah, you're not fighting the charges, is that correct? That's what no contest means. All right, now, Ms. Johnson, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishments, which is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two set of initials. The first set of initials is below a paragraph that's titled Waiver, and the initials are on a line next to a box that should no contendere, which means no contest. Did you place your initials
Yes, sir.
on this document?
Yes, sir.
The second set of initials are below a paragraph that's titled Discovery and Admonishment. And the initials are on a line next to a statement that reads as follows. I did not request discovery of the evidence. I waive my right to request discovery in this case, and I choose to enter a plea of guilty or no contest. Did you place your initials on this document at this location?
Yes, sir.
Now, on page 3 of the same document, there is a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And I also have another document that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Johnson, before you signed and initialed all of these documents that I just showed you, including these as well, and did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Johnson, are you a citizen of the United States?
Yes, sir. State offer states 1.
State is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that I showed you on the tablet. This document is the same document that have your initials in the two locations on page 2 and your signature above the line that's titled Defendant on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
And before we got started on this plea, you stated that you wanted to waive your right to a court report. Is that correct?
Yes, sir.
Okay. Now, Ms. Johnson, is there any evidence that you are currently mentally incompetent to stand trial?
Like, do I have any?
Yeah, I'm saying, is there, okay, do you understand what's going on here today? You understand the consequences of you pleading guilty or no contest? That you'll be placed on, I think the state is offering you deferred probation. Okay. Now, is there any mental problems that's affecting your ability to understand what's going on?
No, sir.
Okay. Now, Ms. Johnson, I will accept your plea of no contest. I will find that there is sufficient evidence to find you guilty beyond a reasonable doubt. I will also find that you are mentally competent to stand trial, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. I will also find that your plea of waivers was freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred, the state's waiving the fine, $320 restitution payable to a Christina Lloyd Salinas.
Hold on, you said restitution,
Yes, Your Honor, $320.
320 in the amount to,
It is Christina Lloyd Salinas.
okay, I see Chris.
Along with 40 hours community service, and this will run concurrent with the separate companion case.
What is a court cost? 277. It's one plus.
They can't come in.
You sent it to me, did you find?
No, oh, that's when I tried to, it disappeared.
Mhm.
Okay. Okay, Miss Johnson. The state is offering. Okay, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you will not be required to pay a fine. You will be required to pay court costs of $277, plus a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you will be required to pay restitution in the amount of $320 to Christina Lloyd Salinas. Now, your total monthly installments will be $137 a month. Are you able to pay the $137 a month or not?
Yes, sir.
You sure you can pay it? This, it's not gonna change, it's not gonna change, what you're gonna get in this case. Okay, so whatever the state offer you is still the same. So you can pay it. All right. Now, you will also be required to perform, is that 40 hours of community service?
Yes, sir.
And now, do you understand? And you also be required to adhere to the other standard terms and conditions of this probation. Now, Ms. Johnson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Ms. Johnson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Johnson, we're gonna move to your next case. Now, this case is running concurrent with the,
Yes, Your Honor.
this case will be running concurrent with cause number 24 CCCR 1092. That means they're running at the same time. I also have before me in cause number 24 CCCR 1844, a document that is titled information sheet. And in this information sheet that was filed by the Jefferson County District Attorney's Office, it alleges, oh, I clicked on the same
Did we
case.
not, I was going to say, did we not just do that?
Yeah, I
first?
just
Okay.
clicked on the same case. Let me go. Okay, I have before me cause number 24 CCCR 1092. An information sheet that was filed by the Jefferson County District Attorney's Office. And in this information, it alleged that you, Kenaya Johnson, on or about March 30th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Johnson, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Johnson, how do you plead guilty, not guilty, or no contest?
No.
Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Now, Ms. Johnson, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of the same document, there are a set of initials. KJ. The first set of initials are below a paragraph that is titled waiver, and they are on a line next to a box that's checked no contender, which means no contest. Did you place your initials on this document? The second set of initials is below a paragraph that is titled discovery admonishment, and the initials of KJ, and they are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials?
Yes, sir.
Second location on this document. On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
Yes, sir.
And is this your signature on the line? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
And as stated previously, you acknowledge that you recognized, read, and understood everything in these 2 documents, and they are a waiver of counsel for purposes of entering a guilty plea and a judge's explanation of rights to defendants without attorney. Is that correct?
Yes, sir.
And you acknowledge that everything in this document was true and correct to the best of your knowledge.
Yes, sir.
Now, and just for the
Oh, I'm sorry.
And just for the record, all of these documents that I just showed you, did you read the documents? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Ms. Johnson, you previously acknowledged that you are a U.S. citizen, a citizen of the United States. Is that correct?
Yes, sir.
And state?
Yeah, state.
Now, the state is offering state's exhibit number 1. In this case, state's exhibit number 1, in this case, it's a document that you acknowledge that you recognize, which is the misdemeanor plea admonishments. And on page 2, the same document that have your initials in the 2 locations and have your signature at the top on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's exhibit number 1 will be admitted. And Ms. Johnson, you previously acknowledged that you were mentally competent to stand trial. Is that correct?
Yes, sir.
So the court is going to find, well, first of all, the court is going to accept your plea of no contest in this case. The court will also find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement
Yes, Your Honor.
in this case?
Yes, Your
And
Honor.
what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred, fine is to be waived, 40 hours community service plus court costs. This will also run concurrent with clause 2-3 CCCR 1844.
We have community, let's see, you got 40 hours of community service?
Yes, Your Honor.
So the court cost is 277? Actually, no restitution?
No, Your Honor. Everything.
Okay. So let's see. Okay. Now, Ms. Johnson, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you will not be required to pay a fine. The fine is being waived. You will be required to pay court costs in the amount of $277. You will also be required to pay a probation fee of $6 a month, year announcement $15 a month, reimbursement fee of $15, which comes to a total of $108 a month. Will you be able to pay that? Let me do this. Now, because you're already on probation, this case will run concurrent. You will not have to pay the probation fee of $60 a month because you're already paying probation fees. You will not have to pay the your analysis fee of $15 a month. You will be required to pay a reimbursement fee and the court costs, which comes to a total of $27 a month. Will you be able to pay the $27 each month? Okay. You will also be required to perform 40 hours of community service. You will also be required to adhere to the other standard terms and conditions of your probation. And this case will run concurrent with cause number 23 CCCR 1844. Now, Ms. Johnson, do you understand the state's offer? Do you think that the state's offers in your case is fair and just? And do you accept the state's offer? Ms. Johnson, I'll follow the plea bargaining agreements that you have entered into with the state. Now, Ms. Johnson, if you successfully complete your probationary period in these two cases, these cases will be dismissed without resulting in conviction or record, and you may be eligible for a non-disclosure. You can talk to an attorney about a non-disclosure. Okay. Now, Ms. Johnson, this will conclude your cases. And she just have a seat in that first chair by the wall, and once she finishes here, you'll be free to go and you have a blessed day. And do we have any bond forfeitures? Let's see, page 1, page 2, page 3. None. Page 4. None. Page 5. What about TJ Landry?
That's transferred.
Okay, transferred. In the conflict. Let's see, Mason was appointed on that, okay. We have Demetrius Shaquille Marquise Murphy. Okay, Demetrius Shaquille Marquise Murphy, scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Demetrius Shaquille Marquise Murphy at the courthouse door. Mr. Marquise Murphy did not answer. Mr. Marquise Murphy has not appeared in court since the court has been in session. The time now is 1:18 p.m. on today's date. Ms. Bailiff, would you please call the name of the Demetrius Shaquille or Demetrius Marquise Murphy at the courthouse door? Demetrius Marquise Murphy. Last name is Marquise Murphy. Okay, no answer. Demetrius Shaquille Marquise Murphy, Demetrius Marquise Murphy did not answer at the courthouse door. The court's bailiff just called his name again. And the time now is 1:19 p.m. on today's date. He has not appeared in court since the court has been in session. Reasonable time has passed to give Mr. Marquise Murphy an opportunity to appear in court. He's not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Demetrius Shaquille Marquise Murphy's bond will be forfeited and warrants to be issued for his arrest in cause number M328296. Next case is cause number 24 CCCR 0664. Case is style the state of Texas versus Jonathan Bernard Nero. Jonathan Nero was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Jonathan Nero at the courthouse door. Jonathan Nero did not answer. Jonathan Nero has not appeared in court since the court has been in session. The time now is 1:20 p.m. on today's date of July 30, 2024. Ms. Bailiff, would you please call the name of Jonathan Nero at the courthouse door? Yes. What happened to Soul Stain? I thought she said he was here. Okay, no answer at the courthouse door. The bailiff just called this Jonathan Nero's name at the courthouse door. A reasonable time has passed to give Mr. Nero opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Jonathan Nero's bond will be forfeited and warrant should be issued for his arrest in cause number 24 CCCR 0664. Next case is cause number 24 CCCR 1212. Case is styled the state of Texas versus Deontay Sostan. Deontay Sostan was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, bailiff called the name of Deontay Sostan at the courthouse door. Deontay Sostan did not answer. A reasonable time has passed to give Mr. Sostan an opportunity to appear in court. He is not appearing in the state. Do you, well, Ms. Mosby, I see I have a check by that. I thought you said that he had appeared. On page 6, the last one, Deontay Sostan. I know he wasn't in here during the session. Oh, that was a different person. That was Mr. Tijuan.
Yeah. Wait,
That was Tijuan.
Huh? What did it look like, a white man?
He said somebody back there.
Is she talking about the one that I told you how to work?
Yeah, no.
Wait a minute, because that was Booker.
He did go to the back with,
Okay, Jefferson County Court at Law number 2 has concluded with its arraignment docket on today's date of July 30th, 2024. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Okay, you are excused, Ms. Simmons.
So there's